Hi, everyone. I'm Sean with Teach Legal TV and the Smith Law Firm. I wanted to jump on here really quick to talk to you about this Fourth Amendment case that has some strange facts. It's a case out of Saginaw, Michigan, and what was happening was the local parking officers were chalking people's tires and issuing parking citations. Well, this one woman by the name of Taylor had her tires chalked and was issued in excess of 10 citations. Well, she decided to challenge this conduct, alleging that was a violation of her constitutional rights generally. And specifically, she was saying, well, this is a search. Chalking the tires is a search that implicates the Fourth Amendment. And because there is no warrant, then it's a constitutional violation. Well, this case, believe it or not, gets all the way up to the Sixth Circuit Court of Appeals. The Sixth Circuit Court of Appeals does acknowledge that the chalking of tires is a search. Well, the city of Saginaw is arguing that, well, it may be a search, but if it is a search, there's a valid exception to the warrant requirement, and that exception is the administrative search requirement. And they liken that to a city enforcing its housing code laws, whereby they could just inspect a home without having a warrant. The court shoots down that argument and basically says, well, the administrative search exception to the warrant requirement is not a free-for-all for all of your civil officers. And when you're relying on this administrative exception to the search warrant, you have to provide the subject with an opportunity for what they call pre-compliance review. And in this case, that was not done. Interestingly, the complainant, Ms. Taylor, she sued the city of Saginaw and she sued the parking patrol officers as well. The court decides to dismiss the lawsuit against the officer, basically citing qualified immunity for the officer. And what that means is because this law was not settled, was not clearly established, the officer or a similarly situated officer would not have known that this would implicate the Fourth Amendment. So therefore, they're entitled to qualified immunity. But Ms. Taylor is allowed to proceed with her lawsuit against the city. So it'll be interesting to see what happens with this and if other circuits across the country follow suit. So interesting case. Chalking tires implicates the Fourth Amendment. At least it does in the Sixth Circuit at this point in time. Again, this is Sean with Teach Legal TV. And if you find this interesting, leave a comment below.